Are you proceeding with sentencing?
Yes, Judge, we waive PSA.
All right, anything you wish to say on behalf of your client?
No, just that she's committed to doing well and wants to do well under probation.
All right, do you have any children?
Yes, ma'am, I do.
How many?
2,
What are their ages?
22 and 17.
And where's your 17-year-old?
She's at home
Who's with
with
your
my
son?
son.
With who?
With my son.
And there's no other adult in the house?
No, with them.
All right, when's the last time you were employed?
About 8 years ago.
Doing
Yes.
what?
Disabled, Judge.
All right, what's your disability?
I have seizures and nerve damage on my right leg.
How often are you using meth and heroin?
Yeah.
Okay, let's not do that because you're here for
Buckle up, everyone. Today we're looking at a courtroom hearing where the tension builds almost immediately. From the very beginning, it's clear this won't be a routine proceeding. The judge wastes no time making it known that she's not convinced the defendant is a good candidate for probation, setting a serious tone for everything that follows. As the hearing continues, the defendant's background and circumstances begin to unfold, revealing the factors that brought the case before the court. With each new detail, the stakes become more apparent, and the atmosphere grows increasingly tense. Although the exchange remains calm and controlled at first, there's an unmistakable sense that the situation could escalate at any moment. What starts as a measured courtroom discussion soon becomes the foundation for a much more intense confrontation.
using meth and heroin before you went to the jail.
Heroin I don't use. Meth I would use it like here and then. Something.
This is not a here and there meth use because I've read the police report.
It's here and there.
So you're getting in a strange car with a guy you don't know, just taking a ride from him, and he just happens to have heroin and you just happen to have meth. I don't know anybody who's not under the influence who's accepting strange rides from people unless they're children. How old are you?
I'm 38.
So you're 38, so you're not accepting rides from complete strangers, which is what you told them in the police report, that you didn't even know the driver. You were just accepting a ride. Who does that? So when the police arrested you, how often were you using meth?
I was a gram a day. 3 grams a day.
So why were you just not honest with me about that? Why are you pretending like you don't have a drug problem? Everybody on this planet has something.
The hearing takes a sharper turn as the judge begins questioning inconsistencies in the defendant's account, focusing particularly on statements about drug use. What initially sounds like a casual denial soon becomes a central issue, with the judge closely examining whether the defendant's explanation is truthful and consistent. The defendant's attempt to minimize the situation by describing the drug use as happening only here and there fails to convince the court. Rather than accepting the explanation, the judge challenges the inconsistencies and carefully breaks down the narrative, piece by piece. As the questioning continues, the pressure inside the courtroom becomes increasingly evident. With each response, the judge grows more skeptical, turning what began as a routine exchange into a tense moment where the defendant's credibility is placed under intense scrutiny.
That and improve who we are. I mean, you've already pled to a drug case. I've read the police report. So you're not sober, you're using drugs. And in order to become sober, you're going to have to admit that you first have been using drugs and that you have a problem. Otherwise, I can't help you. Otherwise, maybe you should just go to prison. So you just want to go to prison and do your time?
No, Judge, I think she might have been confused. There was quite a bit of time from the arrest that she was out on bond until today, and her rearrest on the FTA.
I don't think she was confused. I think she is trying to pretend like she doesn't have a drug problem. But it's obvious you do. So we're going to take care of it if you want it taken care of.
She does.
So, counsel, has there been anything that she's done to support her habit that would make her a better candidate for Esperanza Court? Because felony drug court, they have a waiting list.
I'm not aware of anything.
The hearing takes a more serious and personal turn as the judge addresses the defendant's continued denial head-on. Rather than focusing solely on the legal issues, the judge stresses an important point. Meaningful change can only begin when someone is willing to acknowledge the problem. The discussion shifts from courtroom procedure to personal accountability. With each statement, the judge makes it clear that avoiding responsibility will only make the situation worse. The conversation becomes less about defending past actions and more about recognizing the consequences of those choices and the need for honesty moving forward. As the exchange continues, the atmosphere inside the courtroom grows noticeably heavier. The possibility of a prison sentence is no longer a distant possibility. It is presented as a very real outcome. The judge's words serve as a powerful reality check, underscoring that the decisions made in this moment could have lasting consequences for the defendant's future.
She's done in the past, that's good.
I know we spoke to pretrial about potential. She talked to pretrial about potential just substance abuse treatment and stuff.
Well, what I'm saying is there's a certain requirements for Esperanza Court. Do you want to speak to her and see if she meets the requirements of Esperanza Court?
At this time, I'm not aware of any, Judge.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated in prison. Suspended and probated for 5 years. There's $1,000 fine, probated. There's going to be a referral to felony drug court. That'll be the first referral. Then it will be Esperanza Court. That will be the second referral. I'm going to want a TAP evaluation while in custody.
Can that happen before the holidays, Judge? I would like to see her out for the holidays.
It's not going to happen before the holidays. It's whatever they have.
The hearing now shifts toward the defendant's future, with the court carefully weighing the available options alongside the potential consequences. Much of the discussion centers on treatment programs and whether they could provide a path toward rehabilitation. However, uncertainty surrounding eligibility and the defendant's circumstances makes it clear that there are no easy solutions. As the proceedings continue, the judge outlines a structured sentencing plan that includes probation, financial penalties, and referrals to appropriate treatment and support services. Each condition is explained carefully, emphasizing that every requirement is designed to encourage accountability while giving the defendant an opportunity to move forward. By the end of the hearing, it becomes evident that the court is offering a second chance, but one that comes with significant responsibilities. The judge makes it clear that this opportunity is fragile, and the defendant's future will depend entirely on following the court's orders, complying with probation, and demonstrating a genuine commitment to change.
Judge, is there any way we can have an appointment for that? I just would hate, since we are granting her probation and saying that she is a candidate to be out, that she doesn't get to spend the holidays with her family.
My fear for your client, Ms. Martinez, because she's been dishonest to the court, is that she's going to use. And here's the thing, be it heroin, be it meth, that could be the last time she uses.
The drug test every single day I will.
No. So that'll be TAP evaluation while in custody. All right, good luck to you. We can go off the record. I know you want to be out for the holidays. Everybody wants to be out for the holidays. But this is what I can tell you. You're trying to set up your future, right? And your children, 17 and 22, you can always celebrate the holidays after the holidays.
I wonder, like, are she 17?
I think she knows about Santa Claus and everything. And she knows what Christmas is about.
I'm not that they have.
Yeah. Well, here's the thing. If you're all that your 17-year-old and 22-year-old have.
The hearing reaches one of its most emotional moments as the defense asks the judge to show leniency, hoping the defendant will have the chance to spend the holidays with family. The request highlights the personal impact of the case and adds a heartfelt dimension to the courtroom proceedings. The judge, however, remains focused on a much greater concern. Rather than considering only the immediate emotional appeal, the court emphasizes the serious dangers of relapse and the very real risk of a potentially fatal overdose. From the judge's perspective, the priority is protecting the defendant's long-term well-being rather than granting short-term relief. As the discussion unfolds, the atmosphere inside the courtroom becomes noticeably more intense. What began as a legal sentencing hearing evolves into a sobering conversation about addiction, recovery, and the consequences of life-altering decisions. It is a powerful reminder that the court's role extends beyond punishment, addressing choices that could ultimately determine the defendant's future.
Number two, you have health issues where you shouldn't be using meth. And let me ask you this question. If you hired me as a babysitter for your 17-year-old and 22-year-old, just to be there, because sometimes you want an adult in the house, right? To look after them, to make sure everything goes well, right? And let's say your attorney recommends me to do that, and you check all of my references, they're great. And your children say, yeah, we like Stephanie. Let her come by whenever you can't be here to make sure everything is running well. And you decide to hire me. And as I'm leaving, I tell you, I probably should let you know, I do a gram of meth a day. Would you still want me looking after your 17 and 22-year-old?
No.
That's the position you're in. You are that babysitter who's doing great with the children, and then I'm going to hire you, and then you turn around and tell me I've been using a gram of meth a day. That's not good for your children. You understand?
Yeah.
And honestly, I don't know what would happen if I would release you. You may end up using, and that may end up being a bad batch, and you may end up overdosing. Then what kind of holiday would that be for
The
your
hearing reaches one of its most memorable moments as the judge uses a simple yet powerful babysitter analogy to explain the seriousness of the situation. Instead of relying on complex legal language, the judge delivers the message in a way that is clear, direct, and easy to understand. The comparison immediately captures the courtroom's attention and underscores the point being made. Through this example, the judge emphasizes how trust is affected when drug use becomes part of the equation. The analogy illustrates that rebuilding confidence is not automatic and that actions have lasting consequences, especially when safety and responsibility are involved. At this stage, the discussion goes beyond the legal issues of a case. The judge's remarks become a broader lesson about accountability, honesty, and the importance of earning back trust. It is a powerful moment that leaves little room for misunderstanding and reinforces the expectations the court has for the defendant moving forward.
To reconsider, I just think that there was confusion with the time of the offense versus today, which has been quite a bit of time. To be successful in this probation and to trust in the process, I think that giving her the time out and allowing her to decide to do well and show this court that she can do well, and she's willing to do daily UAs. I don't think she was trying to be dishonest with the court at all. I do think she just didn't understand and the difference between then and now. If there's just anything the court can consider, any condition, she'd be happy to meet to be able to spend the holidays with her family.
All right, thank you. And I appreciate the argument that you've given, counsel, but my ruling stands. Good luck with you. Are you the same Valerie Lorraine Martinez who's placed on community supervision in 2022, CR 5304, for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on December 20th, 2022, for a term of 5 years? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Valerie Lorraine Martinez, did then and there fail to report to the supervision officer as directed for the months of December 2023 and January 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And Your Honor, we waive the other violation alleged in the motion.
Any objection?
No.
Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation. I believe the defense would like to be heard.
All right, defense.
Judge, Ms. Martinez, the court has given her many opportunities that she's had a couple of different things in the Esperanza court. Then she was medically ineligible for one of the treatment programs. That the treatment programs have not worked out for her. She's actually asking the court to be placed just on regular probation and to let her go forward. She's actually got 200 days credit from all these different times that she's been in and out of jail and waiting for beds and waiting for treatment facilities. So she'd just like to be placed on regular probation and go forth in that way.
All right. Any objection to the court reviewing the court summary from probation?
No, ma'am.
No,
Hank has
okay.
that.
Thank you. Oh, I have it.
Okay.
All right.
As the hearing nears its conclusion, the defense makes one final appeal, arguing that confusion contributed to the defendant's actions and asking the court to grant another chance. It is a last effort to persuade the judge that the defendant deserves additional leniency despite the circumstances. The judge, however, remains firm. Rather than focusing only on the latest incident, the court turns its attention to the defendant's history of prior violations. One by one, those previous failures to comply with court-ordered conditions reveal a pattern that cannot be overlooked. By this stage, the tone of the hearing becomes unmistakably final. The discussion is no longer centered on what the defendant might achieve in the future, but on a record of repeated missed opportunities and continued noncompliance. The judge makes it clear that past chances have already been given, and those repeated failures now weigh heavily in the court's decision.
And they get you back with a certain time frame, they still want to work with you. They said they tried outpatient treatment with you, sober living with you, all of the Esperanza Court resources. There's nothing else that can be done for you. And if you could not follow through that program, there's no reason for me to believe that you would follow through on probation. You'll still have the same problems. It appears that you've just been running from your problems, running from treatment and continuing to use drugs. So I don't believe probation, that you're a good candidate for probation. Everything has been tried with you.
I've been cooperating and I have been clean. No.
No, according to this, Esperanza Court removed you from their program. I know, and I'm not taking into consideration, but you absconded.
Satisfying 3 months outpatient rehab. I did complete the recovery in motion program. I got my certificate.
All right. So here's the thing. If we could all write our own program, we wouldn't be here. If you could write your own program to remain clean and sober, guess what? You wouldn't be on probation for possession 1 to 4 grams. If you could write your own program to be clean and sober, guess what? You never would have tested positive while you're on probation. You can't write your own program, and that's what you're trying to do. I'm going to grant the motion. All right, with regards to time, state, what are you requesting? And defense, what are you requesting?
We're leaving to 4 years.
State?
Judge, we'd ask for the minimum. She has been in and out of these different programs. She has at least attempted to comply on multiple occasions. So we would ask for the minimum.
All right, has she paid the $114 restitution? Did you pay the restitution of $114?
I did make payments, ma'am. Yes, ma'am.
Okay. All right, has she successfully completed any inpatient treatment?
So it looks like she was disqualified from DDRF. She was medically ineligible. Then the felony drug court, she was referred to the Esperanza Court. And then the Esperanza Court is when we started to have some problems.
All right, this is what the court is going to do. The court is going to revoke you. The court will sentence you to 4 years in the prison, give you credit for any time served. There's a $1,000 fine. Time and money will run concurrent. And I'll recommend the therapeutic community for you. I can recommend it, but you will have to ask for it because I have no jurisdiction to force them to place you in the therapeutic community.
Then runs dry. Excuse me.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You're going to have to stop using drugs. Otherwise, the last time you use may be the last time you use. When you're released from prison, if you can't find any of the free places for drug treatment, you can always come back here. If I'm here, then I will direct you to a place.
The hearing reaches its decisive conclusion as the judge carefully reviews the defendant's entire history, including unsuccessful treatment attempts, repeated probation violations, and continued drug use. Although the court acknowledges that some efforts were made, it ultimately determines that those efforts were not enough to satisfy the conditions of probation or demonstrate lasting progress. After considering all of the evidence and the defendant's record, the judge delivers the final ruling. Probation is revoked and a prison sentence is imposed. It is a sobering decision that reflects the court's conclusion that repeated opportunities for rehabilitation have not resulted in meaningful compliance. Even as the sentence is announced, the judge's closing remarks remain measured and compassionate. While emphasizing that the consequences are now unavoidable, the judge reminds the defendant that personal change is still possible and that the future will depend on the choices made from this point forward. That brings us to the end of this intense courtroom breakdown. If you found this analysis informative, be sure to like the video, subscribe to the channel, and turn on notifications so you don't miss future courtroom breakdowns. Thank you for watching, and we'll see you in the next video.